Hi, everyone, and welcome back to this conference on disability and rights under neoliberalism. We've reached the final panel of the conference on regulating our rights, the limits and strain of legalism, and we are just before the keynote, so we have two sessions to enjoy still. So my name is Arianna Introna, and I am a member of the Marxism and Disability Network Steering Committee, and I'm delighted to be chairing this session. We have two speakers, but I will introduce our first speaker first. So Aher Perez Casanovas, who will speak to us about individualism, recognition, legalism, from rights to justice. And Aher is a scholar specializing in pragmatist philosophy, care ethics, and disability justice. She earned her PhD in citizenship and human rights from the University of Barcelona, cum laude, well done, examining aesthetic experience and democratic participation. Her research explores how embodiment and sensory engagement shape inclusive policies in education and cultural institutions. Through projects like Beyond the Visual and Pain Pulse, she advances interdependence and collective access. Active in networks like Women in Pragmatism, her work integrates ethics into public decision-making to foster more inclusive environments. Disability rights frameworks, exemplified by the United Nations Convention on the Rights of Persons with Disabilities, have secured legal recognition for disabled people globally. However, these rights remain entangled within neoliberal legalism, often reinforcing individualistic, market-driven solutions that fail to address systemic oppression. In contrast, disability justice, emerging from the activism of queer disabled people of color, centers intersectionality, anti-capitalism, and collective access as strategies for dismantling ableist structures beyond legal reform. So this is very exciting. So here I will just share your slides, and
Thank you.
and you can kick off.
Okay,
So
nice.
So I will share. Can you see?
Yes, I can see the window with, yeah, that's perfect. Can everyone read that?
That's
Okay, nice.
yes.
Okay, so
Okay.
thank you so much, Ariana, for the introduction. I will present myself first. I'm Majer. I go by she, her pronouns, and just a short visual description. Today, my hair is braided because it's the most comfortable for me when I do this kind of conferences. And I'm wearing my glasses because otherwise it would be quite difficult for me to do the presentation. And what today I want to discuss is a problem that arose after my PhD, which I earned quite recently, like a year ago, and that is the problem of normativity in disability justice, because I focused mainly on the shift from disability rights to disability justice and have been working for 5 years now, mainly with artists and activists in the United States and Canada, Vancouver, who are very much into doing small crib-liberated zones and small communities that arise around their practice. But since my other part of research dwells on mainly on pragmatism, the question of normativity and mainly how far can we extend different modes of establishing relationships among one another kept arising. So that is something that I want to discuss with you today, because we will see that it's a dialectic that is quite juggling, and that if we keep on the tradition of recognition that comes mainly from the critical theory and Frankfurt School, and especially Axel Honneth, it is quite difficult to make sense of this kind of practices. So that's going to be our challenge today. So if we can go to the next slide, Ariana, please. Thank you. So first, I will reintroduce a distinction that may be familiar for some of you, which is disability rights and disability justice, to move on to how this, the main theory of recognition is something that was born within a welfare state of Western democracies. And for that reason, it is very based on rights recognition. And it is, of course, it depends on the context where it was born, and therefore the social structures on which it is based, although they aspire to be universal, as we will see, may limit their explanatory power, and maybe some social movements that are emerging right now, not only in identity politics, but in grassroots organizations, are difficult to understand from this perspective. To exemplify this, we are going to take the case study of disability justice activism, especially how this activism transcends the rights recognition from individuals as citizens of a democracy, but rather aims to transform the very own substructures that structure and that articulate how we relate to each other, and create a kind of community that we will see whether can be fitted into one of the existing categories of recognition, or is a qualitatively different kind. To see this, I will just mention two case studies, which is Carmen Papalia's Access Art and the Disability Justice Dreaming Sessions, which were led by Rebel Rose, but have continued as with their own functioning. Okay, so if we can move to the next one, please. Okay, so just to set the framework, we can trace a historical different and an historical transition from the first wave of disability rights, which were grounded mainly on recognition of legal rights, accommodation, access to the workforce, and mainly inclusion, as they already conceptualize it. And we can set a milestone of it in the passing of the Americans with Disabilities Act in 1990. And here I want to do something that was already mentioned yesterday in Rabi Malorta's presentation, which is recognizing what we have gained with that, recognizing that there is, we could say, some kind of progress, or at least some kind of advance and broadening of the scope of recognition with the Americans with Disabilities Act and the different social movements that were afterwards institutionalized, that mainly were born after the emergence of the social model of disability. And of course, that is something that we have to recognize. But after the first wave of disability rights, mainly a collective that was built around performance and art in the Bay Area, which is called, it still exists, which is called Scenes Invalid, started to identify how the first wave of disability rights made hyper visible a very specific kind of disability, which was mainly wheelchair users and people with mobility disabilities. And for this reason, they set out to create a different kind of movement that amplified the intersectionality of this recognition, and that could make sense and honor the experiences of Black, Indigenous, people of color with disabilities, queer people with disabilities, well, LGBTQ+, also class issues that were very on the side of disability rights, here became the focus. And for this, they created the disability justice movement, which has been gaining a strength and gaining different bubbles across the globe and gaining also legitimacy through the academization of it and the publication, for example, of the Skin, Tooth and Bone volume, which not only states the principles of the movement, but also gives practical tactics and strategies to mainly collectivize access and collectivize disability justice as something that structures the whole social fabric. Another field where this has been prominent is in artistic practice and also curatorship. And here I just want to mention Amanda Kacha, who has been one of the forerunners of curating as an accessibility practice and as a caring practice that can be the excuse and somehow the motive to build a community around the exhibition or to build a community about this around these kind of practices. So the difference between disability rights and disability justice is that disability rights was explicitly aiming at integration and inclusion in an already existing system, which was mainly the legal system, whereas disability justice is a much broader project that has, I argue, very serious philosophical implications because it obliges us to rethink and reconceptualize our very human nature, mainly moving from a primacy of individuality to a primacy of intersubjectivity and interdependence in different degrees. And that that change on the grounds is something that will then transform all the whole building and the political project that it's built upon this basis of the movement. So if we move to the next one, we can see how in the first wave, the main objective and something that was the victory at the end of disability rights was the acquisition of rights in this already existing system. So that means, as we can see in the graphic, mainly access to equity scholarships, income support, technology, mainly medical technology, public transport, physical access, which was very much one of the main measures after the ADA, which was accommodation of buildings, so architectural, the so-called allegedly universal architecture and universal design. But as we can see, it is accommodating the state of affairs to the difference so that the difference can enter into the status quo at the end. So if we move to the next one. Thank you, Rihanna. So if we move to the next one, we can see that the whole objective of these fights for recognition, in this case, the recognition of legal and civic rights for people with disabilities, could be quite understood from the perspective of theories of recognition. And here we will mainly draw on Honeth's interpretation because although we will see that it has its limitations, it is quite subtle and it is quite complex in the sense that it recognizes that there are different modes of interrelationships and different needs that need to be covered on different spheres. So here we can see that Honeth understands that the whole idea of progress and of not only political progress of a society, but also its moral progress in the sense that how it makes life better, a good life for everyone, is built upon two notions. The first one is integration in these spheres of recognition, and the second one is individualization, in the sense that each individual, each citizen realizes its full potential, and realizes its interest and its capacity to be cultivated and to develop their different passions. So in this sense, it is quite an interesting proposal, because it is a developmental logic, in the sense that it is still quite optimistic, because it's Frankfurt School, but it's third generation. So there is a faith, a belief, and a hope in the progress, and in this case, pluralistic progress in modern societies that advances, according to Axel Honneth, thanks to these struggles for recognition. So these three spheres can be separated, and it is still quite puzzling how these spheres articulate structures of recognition, because although these are the spheres, there may be different internal organizations and internal structuring of relations that combine some of them. So what Honneth does is he looks at the current state of post-traditional societies, and he notices that there are mainly three modes of recognition, which are in the private sphere, that develop into mainly relationships of love and intimacy. For him, this sphere is what generates self-confidence, and is the background for then moving on to the more public spheres. We have the legal sphere. It's mainly the rights and the recognition of someone as a generalized other, as a citizen of a society that has the right to be treated with equity with the rest of the citizens, and this creates self-respect as part of the society. And then we have the solidarity sphere, which is, if the legal was the generalized, the solidarity sphere is where we can develop our own individualized and specific interests. And this creates self-esteem, and it's where an individual, and here I take on the pragmatist tradition of Dewey, it's where growth can happen, where human flourishing can happen. So Honneth takes these three spheres, and from them he induces that they stem from a universal and transhistorical anthropological need, three needs, which are love, that creates intimacy, a need for legal equality and respect, that creates the legal sphere, and a need for achievement and social recognition, like peer recognition, that creates this solidarity. So Honneth argues that there are these three spheres, and these three spheres are what can lead to the fully realized potential of recognition relations. The opposite of this recognition would be social exclusion, which would correlate then to not fully realized potential of recognition relations, with a justified motive, according to him. But there is a gap for him between these spheres that constitute the transcending and overarching process that is leading towards moral progress in post-traditional societies, and how it takes place in the real history with real struggles for recognition that happen in specific groups, and especially in specific communities. So we can see that it has the advantage of explaining disability rights, because it can be understood as a very specific struggle for recognition, where individuals who are historically excluded from these spheres gain access to them. But disability justice is a bit more difficult to make sense of with this schema, because this schema implies that these spheres stay untouched after the struggle for recognition. So if we move to the next one, please. Yeah, can we move to one more? Because I already introduced that. Okay. With disability justice, what the movement claims is basically a radical prefigurative politics where we imagine in the sense of, I take here Maxine Green's idea of social imagination. It's not just imagining as a dreamy, world-fleeing event, but rather a very active motor that puts us into action to transform the current state of affairs. But the base is that we imagine a radically different way of relating to one another, as I mentioned, that it's built into interdependence, intersectionality, cross-sectional solidarity, and collective access. So here, the problem with disability justice is that these exercises of imagination that do indeed put into motion something happen with very specific communities. So if Honeth, as we have seen, mainly focuses on society as a whole, disability justice takes place in if we take into account Tony's distinction between communities and societies, it would happen into communities because a community is characterized, I quote, by the reciprocal recognition of specific attributes that members share as distinct subjects, or a distinct group of persons. So in disability justice communities, what happens is that through these exercises of imagination and through different strategies, for example, access checks, there is a mutual recognition of these specific attributes and specific identity. However, if we stay in the level of community, and this is the challenge, we will stay always in this local scale of the movement. And what the aim behind this prefigurative politics is to transform society as a whole. Why? Because society, and I quote again, society involves the shared recognition of those values that are mutually shared by all members. And here I think it's a key distinction between, yeah, we can move to the one with the photo. Next one. Yeah, this one. Here, I think it's the main difference between disability rights and disability justice, because while disability rights, there is a recognition of a community with specific attributes that it's then integrated in an already existing system of institutions and values. With disability justice, and this is why it is more radical in degree, there is an aim to reshape the limits of the spheres of recognition as they are, to reshape the institutions, and to transform the values that structure us as a social fabric and as a society. And for this reason, it cannot be fully accounted through this theory of recognition, but needs a social theory that focuses more on how social conflict transforms the very own spheres of recognition. And in this case, we can resort to pragmatism, because John Dewey, in his lectures in China, has a theory of social conflict, where, in contrast with Honeth, where the struggle of recognition and the struggle of community claims rests upon a community that wants to be integrated and wants to follow the same logic as the already existing one. For Dewey, the problem, the conflict does not arise from a community or from a specific set of rights that need to be standardized or a specific set of attributes, but rather on the very own principle that it's articulating the community. So, for example, one of the main examples he gives, it's the conflict between the medieval social fabric structure around faith with the modern social fabric that wants to be structured upon science. And here it's quite useful because we can think of this disability justice sphere that aims to that functions with a different principle, because if we contrast it, for example, with workforce and the sphere of labor, of neoliberal capitalistic labor that is ruled under a principle of productivity, disability justice operates with a different logic. And what it aims to do is, with the communities, at least preserve these spheres that function under a different principle and resist the colonization of, for example, the productivity principle. But if we transcend into its social motive, what it aims to do is restructure the rest of the spheres of social relationships so that this principle of interdependence and care can be extended into other realms. And how does it do that? So it doesn't do it with a very violent colonialism on over other spheres, but in the current state of the movement, the main tactic for this overarching strategy of extending care and interdependence is artistic practices. And I just will mention Carmen's practice because I want to leave room for doubts, but Carmen's practice is a practice around accessibility that started as an act of self-advocacy. When Carmen Papalia was named legally blind, he resisted the identification with the normative marks of disability and marks of blindness. In this case, the white cane mainly. So in the first period, he did a lot of experimentation around long canes, using a speaker instead of a cane, and different practices that kind of disrupted how we perceive blindness in the public space. From that, he moved on more disability justice informed collective practices, where he constructs a grouping around his practice that is ruled under a different principle. And in this case, since it's very immersive, what he does is he shifts the perspective from what he calls visual learners, people who guide themselves, especially around public space, with the sense of sight, to tactile or non-visual learners. And for this reason, he does experiments like the blind field shuttle. The blind field shuttle is a performance that consists of Carmen leading a queue of people who are touching each other so that they can follow the queue. Yeah, so that they can follow the queue with their eyes closed. And he's the one leading because he's the one who has expertise in moving around the public space, not using the visual sense. This is just a trigger for posterior reflection upon how we structure public space, who has access, who hasn't, and how we relate to each other in these spheres. And it is, as I said, a practice of prefigurative politics and a practice of understanding access as love and as a completely qualitatively different sphere of recognition. And I'm going to end here so that we have room for questions and for the next speaker. Thank you so much for this space. Oh, I see something about the language.
Sorry. Yes, thank you so much,
You're
Azure. Sorry,
welcome.
I'm messaging you. Sorry for the overwhelm. Yeah, thank you so much. That was a wonderful talk. I'm sure we have lots of questions. So thanks so much. Really amazing stuff. So let me see if we have Lydia. Hi, Lydia. Great to see you there. So, if I'm right, you will not be using your camera, which is fine.
Hi, yeah, that's correct. I've got a bit of an internet problem.
Amazing. So, would you like me to share your slide?
Yeah, that would be good, actually. Thank you.
So now I will introduce you. So thanks again, Asher, for a wonderful presentation. And we will move now to our second speaker for the session on regulating our rights, the limits and strains of legalism. And our second speaker is Lydia Kitson, who will present on a paper titled The Margin of Appreciation and the Fragility of Disability Rights in Public Health Emergencies. So, Lydia is a third year PhD student at the University of Leicester, researching human rights and equality in the allocation of scarce ventilators during the pandemic. Lydia's broader research interests reflect human rights and health, with a focus on the discrimination faced by people with disabilities. And Lydia will speak for about 20 minutes, and then we will move to questions. And a bit of housekeeping, sorry, I forgot to say it earlier. So just a reminder, if you can mute your microphone, and if you would like to ask the speakers a question, if you could please post your question in the Q&A box, which you can find at the bottom of your screen, where there is a button saying Q&A. And if you can specify who your question is for. We won't read out who the questions are from, so your information won't be shared on the recordings. And if you are unable to type and need to ask your questions, please raise your hand or draw my attention. And this is because so I'm trying to sum up. So I'm sure you will be asking your questions respectfully so that we can have our conversation in an inclusive and safe space. The other point is just a reminder not to use the Zoom chat during the presentations, and this is because people using screen readers would have your chat comments read out loud and that. And so they will be unable to hear the speakers. Yes. If you are having tech issues, you can let me know or let Luke know. I think, yeah. 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 And then in terms of BSL interpretation, we have Tracy and Dan-Marie. So if you are a BSL user, please reach out to them directly. Okay, so Lydia, I will just share your presentation. Okay. Yes. Okay, I will start sharing. Can you see the slide fine?
Yeah, that's great.
Let me see this.
Okay, so hi everyone, my name is Lydia and I'm a third year PhD student at the University of Leicester. Today I'll be discussing the margin of appreciation and fragility of disability rights in the pandemic. And as I said, I've been having internet problems, so if you can't hear me, just please stop me and we can try again. Can I get the next slide, please? Okay, so the COVID pandemic revealed the urgent need for clear human rights-based guidance. Early frameworks aimed to maximize health outcomes using what looked like objective clinical criteria, but in reality, these policies disproportionately disadvantaged patients with disabilities, even though on paper, everyone was formally treated equally. This presentation will focus on Article 14 of the European Convention on Human Rights, as it's incorporated into domestic law through the Human Rights Act. I'll briefly refer to the Convention on the Rights of Persons with Disabilities, the CRPD, just to show the development of disability rights, but the focus will be on Article 14 and the limitations of these protections during the pandemic, particularly through the margin of appreciation doctrine, which allows for state discretion when implementing policies that would otherwise violate rights. In order to prevent systemic discrimination in future crises, it's important it's important to create clinical guidance explicitly grounded in human rights protection. This would limit states' abilities to rely on this degree of discretion, which would otherwise be used to justify practices that would indirectly discriminate. And then just lastly on this slide, my research adopts a doctrinal approach to assess the legality of these policies from a human rights perspective. Understanding this also requires a socio-legal angle to help uncover the hidden discriminatory assumptions that result in unequal protection of rights. Can I get the next slide, please? The pandemic exposed the limitations of formal equality in safeguarding patients' rights. This model assumes that treating everyone equally ensures fairness, but it overlooks systemic barriers and individual circumstances. It can also be overly permissive of state discretion, particularly in emergencies. Although it does prohibit direct discrimination, it still allows for indirect discrimination, which reinforces existing disadvantages. For example, while disability wasn't an explicit exclusion factor for treatment decisions, other factors like quality of life judgments and comorbidities disproportionately affected those with disabilities. And by contrast, substantive equality focuses on fair outcomes. It recognizes group-based disadvantage and is reflected in how Article 14 has developed to protect also against indirect discrimination. In the past, the dominant medical model treated disability as something to cure, and this led to excessive clinical discretion and decisions that effectively devalued lives. This approach can be seen in the use of do not resuscitate orders and ventilator allocation policies. In contrast, the shift towards the social model reframed disability, so it's seen as a consequence of social and structural barriers, and this model is reinforced by human rights developments, yet the pandemic did reveal how fragile that progress remains. And in terms of intersectionality, this lens is crucial because inequalities don't operate in isolation, which is something the formal equality approach would suggest. Instead, they can interact and magnify discrimination. In particular, my research shows how age and disability are treated as overlapping clinical risk factors, resulting in compounded discrimination. To understand the real impact of these emergency policies, we must consider how these different forms of disadvantage intersect in practice. Can I get the next slide, please? So before turning to Article 14, it's important to briefly examine the NHS's clinical decision-making framework, particularly its use of cost-effectiveness measures, like the Quality Adjusted Life Year. This is used to compare treatments and patients based on life expectancy and perceived quality of life. On paper, this approach appears neutral and objective, but it's heavily criticized as it assumes automatically a lower quality of life for those with disabilities. So again, it undervalues their lives. Also, older patients are disadvantaged by default, as they're unlikely to gain as many life years. So in practice, this means younger patients without disabilities are more likely to receive treatment in times of scarcity. And during the pandemic, these issues became very real. The clinical frailty scale was used to allocate treatment, and this disproportionately affected those with long-term support or mobility needs. Although it's framed as neutral, these types of tools embed ableist assumptions about who's worth treating and reflects attitudes that reinforce structural disadvantage. This again shows why the social model of disability and substantive equality is crucial. These models shift the focus from clinical diagnoses to systemic inequalities and fair outcomes, which is especially vital in emergency settings. And in addition, the blanket use of do not resuscitate orders for patients with disabilities has received widespread criticism. This is a stark reminder of the Tracy case, which made clear that imposing such orders without proper patient involvement and an individualized approach violates Article 8 of the European Convention, which protects the right to privacy, including autonomy in medical decisions. Can I get the next slide, please? Thank you. The RPD does reflect a shift towards substantive equality and a growing consensus in terms of the importance of protecting against discrimination. However, its aspirational nature and lack of enforcement mechanisms mean that this progress proved incredibly fragile during the pandemic. And turning to the European Convention, Article 14 protects against discrimination in the enjoyment of convention rights. But a violation of one of these substantive rights isn't strictly required, only that the issue falls within its scope. And in this context, triage decisions, ventilator allocation, and do not resuscitate orders clearly raise multiple rights concerns, particularly Article 2, the right to life, and Article 8, the right to private life, which touches on medical autonomy and the need for an individualized approach. So it clearly prohibits blanket policies imposed on groups of patients. In terms of the provision, it refers to other status, so it's been interpreted quite widely in cases such as GLAW and QUTIN to include protection against discrimination on grounds of disability or health status. In both of these cases, the court has recognized the need for special consideration, given the role of group vulnerability and the importance of assessing the impact of policies on these groups. Not all differences in treatment, however, do amount to discrimination. To establish a breach, individuals must show that they were either treated differently from others who were in relevantly similar situations, or that they were treated the same despite being in significantly different situations. This again illustrates how Article 14 moves beyond formal equality and focuses on the actual impact of a policy or decision on groups of patients. So during the pandemic, critically ill patients in need of ventilation can be considered in similar situations. So denying treatment solely based on disability without an individualized assessment could in fact breach Article 14. For example, where the disability doesn't affect survival outcomes, it shouldn't be used to justify withholding or withdrawing care. This is the same with blanket do not resuscitate decisions, and making such a decision solely on the basis of disability likely constitutes direct discrimination, as there's no medical justification just to rely on this protected characteristic. Okay, and Article 14, importantly, also prohibits indirect discrimination. This means it applies to policies that appear neutral but have a disproportionately harmful impact on particular groups. This is especially important for addressing structural inequality and ableist assumptions, such as the belief that those with disabilities automatically have a lower quality of life, as we saw in the NHS's clinical decision-making framework. These assumptions underpinning triage and ventilator decisions reinforce inequality under the guise of clinical objectivity. And interestingly, Article 14 does allow differential treatment in certain circumstances. There must be an objective and reasonable justification, and any measure must be proportionate to the aim pursued. This is where the margin of appreciation plays a key role in allowing a degree of state discretion. However, the court has made clear in cases such as DH and others that people with disabilities are a vulnerable group. Therefore, any differential treatment or lack of must be particularly justified by particularly weighty reasons. And in some cases, states may even be required to adopt positive measures to counteract long-standing disadvantage. This can include historical stigma and ensuring an individualized patient-led approach, one that is free from any generalizations or stereotypes. This means that blanket policies that fail to consider the real impact of a person's disability may therefore be unlawful, as is seen with the use of clinical frailty scores in the pandemic. And then when read with Articles 2 and 8, Article 14 can be considered to impose positive obligations on the state, requiring them to actively prevent and address this disability discrimination. In many cases, such as Kyotin, the margin of appreciation has been held to narrow because of group vulnerability, meaning that states are required to take concrete steps to secure equal access to rights. And in the case of CAM and Turkey, the court has acknowledged that reasonable accommodations may be required to address these inequalities, and failure to do so could amount to discrimination. In another case of law in Switzerland, it was also recognized that the CRPD is clear evidence of a growing consensus on the need to protect people with disabilities. And this level of consensus has been held to narrow the allowed state discretion. And this then strengthens arguments for a rights-based, individualized framework for future healthcare decisions. Get the next slide, please. Thank you. So a key weakness of the margin of appreciation is its inconsistency in case law, especially when assessing the scope of justification for permitted differential treatment and how far any positive obligations may extend. This does reflect a broader tension more generally, though, between protecting fundamental rights and more pragmatic issues of resource scarcity. The scope of the margin can be very difficult to predict because it varies depending on the issue, the context, European consensus, and many factors. So, for example, when there is a clear consensus on a matter, such as clearly with the importance of protecting against discrimination, the margin is significantly narrower. But again, in complex, sensitive contexts, such as the pandemic, where policy decisions are inevitably fast-paced and contentious, a wider margin is typically granted. You can see that this creates a real risk for disability rights. And again, the case of Cam and Turkey is important as the court acknowledged the limits to any possible positive obligations and said that they exist unless they would require a disproportionate or undue burden being placed on states. So while resource constraints must be considered, this reasoning does weaken protections for those with disabilities and can lead to an undue degree of deference to national decisions, especially when made in the name of economic or public health necessity. This issue was also reflected in the Lithuanian case I've listed. Here, the court reiterated that it wouldn't substitute its own judgment for that of a national authority, as long as policies were implemented in a proportionate manner. But this reliance on state discretion, particularly in social and economic matters, does pose a significant risk for those with disabilities when it's clear that systemic discrimination already exists. There is, however, scope to argue that a narrower margin applies here because of the nature of the fundamental rights involved and the intersection with structural inequality. The court has recognized that disability as a ground of vulnerability requires stricter scrutiny by the court in order to protect patients' rights. In the case of Kiutin, again, this vulnerability was found to justify stronger state obligations, particularly to address the lasting effects of stigma and exclusion. So looking ahead, there's also potential for disability discrimination protections to be enhanced and be treated, for example, the same as sex and race discrimination. These grounds have already been described as inherently suspect and requiring very strong justifications. And furthermore, while the court hasn't formally adopted the language of intersectionality, it has recognized the compounded effect of multiple forms of discrimination. This opens the door for a more robust and nuanced interpretation of equality under the convention moving forward, as pointed out by Peroni and Timmer. Okay, can I get the next slide, please? Thank you. Okay, so as we've seen, the margin of appreciation is both a weakness and a strength. In 2020, it was clearly a weakness. The lack of human rights informed full guidance allowed this excessive discretion and permitted discrimination, as it effectively legitimized practices that discriminated against those with disabilities. However, as touched on the previous slide, it is also a potential strength, as it allows the law to evolve and recognize, for example, positive obligations, which could require states to take active steps to ensure equal treatment. What undermined the rights during the pandemic was not just the margin itself, but how it interacted with formal equality and the lack of clear rights-based frameworks. The pandemic itself did illustrate the relative ease with which progress can be undone in both the state as a whole and the NHS in particular, in reverting to formal equality and the medical model. However, these aren't inevitable failings, they can be addressed, and stronger protections are possible if human rights are proactively put at the center of future rationing guidance, so that the role of discretion is considerably reduced. Implementing these positive obligations could be done through developing clear guidelines, as I've said, but this could also require meaningful consultation with affected groups advocating for disability rights, as well as adopting individualized approaches and, importantly, monitoring for discriminatory outcomes in the future should this happen again. These are just some practical steps, for example, towards ensuring that all are treated with equal worth and dignity. And this importance isn't limited to COVID. These issues apply in any situation of scarcity, such as future pandemics, staff shortages, or delays in emergency response times. and the challenge of resource scarcity must never come at the expense of equality. Looking forward, it's also essential that future research explores how disability discrimination interacts with age, race, and gender. These overlapping factors create complex patterns of disadvantage that formal equality alone cannot address. So ultimately, health and discrimination-related human rights are still developing, and the pandemic marks a pivotal moment to confront the weaknesses in the current approach and commit to a rights-based model that places equal dignity at the heart of healthcare, even in times of crisis. So yeah, next slide, please. I've just listed some of my references for anyone interested in looking into this further, so they're a good starting point. And yeah, that's it. Thank you very much for listening, and if you've got any questions, I'm very happy to answer. Thank you.
Thanks so much, Lydia. That was amazing. Yeah, well, I hope people have got will stop share. But if you're interested, just reach out to Lydia for the slide. So yes, thanks so much, Lydia and Asher, for two amazing presentations. We will use 5 minutes for questions. It's not a lot, so I'll check in the. Sorry, I've lost my. Okay, so I have yes. So if just a reminder, if you have questions for Lydia in Azure, if you can use the Q&A box. And the question, I have a question. Share, fantastic presentation. I'm curious about your turn to pragmatism and whether this mirrors David Kennedy's turn to pragmatism regarding rights. If I missed this, but that give us pathways towards disability justice in wider settings that aren't contingent on the specific communities in which they arise.
Sorry, I was muted. Yeah, this is something that we have been discussing mainly in Women in Pragmatism, but also with the European Pragmatist Network. And it's very nice to see that there is a growing interest in developed political theory and social theory that comes from a pragmatist inheritance towards this movement, because the first intersection that we found was that the different terms that are used in the discourse, not only the official discourse of disability justice, and I take that as mainly since invalid statements, but also the 10 principles and the whole semantic field that it's unfolding from the different practices, shared a lot of vocabulary with the social reformists, mainly John Dewey and Jane Addams, and their idea of social ethics, the settlement, the merging of theory and practice, and concepts that had not perfect analogies, but very similarly articulated concepts. For example, in disability justice, there is the idea of leadership of the most affected, which translates this lemma, this slogan of leave no one behind. And in pragmatism, social progress is theorized from the perspective of what Jane Addams calls lateral progress, which is mainly that there is no there is no line of progress where the most exceptional and autonomous individuals are going to peak, but rather there is a common front that is going to advance collectively. And we can only speak of progress if this whole front is taken into account. So it's better to do small steps that are kind of tangential rather than big milestones that benefit a very few segment of the population. So through these analogies, what is rich and what is fruitful is that from these analogies, a dialogue can be established where we reactivate these pragmatist notions and make them useful, like a resource toolbox for disability justice, from a perspective that it's very reciprocal, but also that gives these tools to people who are giving priority to activism. So I think that these are the kind of collaborations that are gaining force. And it's also from these forums of dialogue that it's a very diverse dialogue from which this trend of democratic theory and this theorizing around society and the social fabric as a whole that comes mainly from this pragmatist and feminist pragmatists can give the theoretical background that is also going to enforce measures and initiative in public policing and in more structural changes that individual practitioners cannot attain. So I think that this is something that is gaining force, and that comes mainly from this idea of democratic experimentalism. Thank you for the question.
Thanks so much, Ajar. Wonderful response. Now we have one question for Lydia and one question for both of you. So if you can try and be as quick as possible in your reply, so that it's my fault that we've gone over time, but if you can be quick in your response. So question for Lydia. You mentioned that local health authorities and courts defer to national ones during crisis periods. How much of a departure is this from their usual practice in disputes over medical treatment for disabled people? And then I will ask the other two. So Lydia, if you can answer this question, and then I will ask the one for both of you. Thanks.
Yeah, it's quite a disparity between national and local policies, which is the main cause of the inequality in my thesis, I would argue, because it's the lack of clear guidance that's enforceable that led to this clinical discretion and the permitted differential treatment. And again, with the margin of appreciation that generally was permitted in terms of convention rights, but by introducing proper, clear guidance in the future that puts rights at the center, this can be minimized in future crises. Yeah.
Thanks so much, Lydia. Great answer. Now we need to wrap up because to allow for people and interpreters for a break. But I'm just I'm reading to you very quickly the other question we had, which is thank you very much for your great presentations. I was wondering which national health systems beyond Western liberal, democratic, neoliberal, global North context are or have been moving towards realizing your conceptualizations of disability justice and margin of appreciation. This was a wonderful question. If you can maybe think about this and maybe we come back, I don't know, the person who asked the question and you two, if you want to come back a couple of minutes before the keynote, I don't know. But I don't know if you can think about this, Bill.
Yeah,
or maybe
I'm
yes.
happy to facilitate my email address as well, because that's something that has been developing mainly in South America as well, drawing from different trends like Audre Lorde and Anthel Dua's writings on disability. So yeah, I can get in touch if you want to.
Amazing. Yes. So yeah, the person who asked if you want to get in touch with us, and we will pass your email to Ajar and Lydia the same, if you can.
Yeah, I'm happy to, if they'd like to reach out, I'm happy for my email and my slides to be
amazing
distributed. Yeah, thank you.
Amazing. Thank you both so much, and thanks people who asked the question. That amazing session. You take care, and We'll see you in 15 minutes, 10 to 15 minutes.
Thank you so much.
Yeah, thanks so much. Bye.
Thank you, everyone. Thanks.